Hi! Today, we're starting a series of talks about dispute resolution worldwide. Our experts will tell us about the main features of their systems and share practical tips on preventing and navigating disputes in the international business arena. Our first speakers are Antonio Vela and Lisa Shachne from San Francisco, California, interviewed by Roberto Luzi Crivellini. In this episode, they'll explain when jurisdiction exists in California, the differences between state court and federal court, and why it is important to include a dispute resolution clause in a contract to be performed in the U.S. Make sure you follow Legalmondo on LinkedIn and YouTube to stay updated on the next episodes.
So, hello, Lisa and Antonio, and good evening here in Italy, and good morning in San Francisco, California.
Thank
Hi,
you.
Roberto.
Good to
How
be
are
here.
you doing?
Good. I'm very happy to start this little series of talks on the topic of litigation in California. And I gave a quick background here. This idea came about a couple of weeks ago when we were discussing a couple of cases related to Italian companies litigating in California. And because of the fact that the differences between the two systems, the two litigation systems, are so many and so important, we thought that it would be interesting for foreign companies doing business in California and for their advisors to share some thoughts on the main issues that may affect businesses who eventually have a litigation or potential litigation in California. So thanks again for your availability, and I would start from asking you to quickly introduce yourself. So maybe Lisa, would you like to start?
Thank you, Roberto. My name is Lisa Shachne. I am the head of litigation at Vela and Associates. We have offices in California, New York. We're licensed in Washington, D.C., and we also have a representative in office in Milan, Italy. Thank you for hosting this call, Roberto.
Sure, it's my pleasure. Antonio.
Thank you, Roberto. My name is Antonio Valla. I am the founder of Valla and Associates. I'm a native of Italy, but I've lived and worked in the United States for 40 years now. And most of what our firm does is represent foreign companies, not necessarily Italian companies. We have clients throughout Europe, Latin America, but foreign companies that do business in the United States. And doing business in the United States often implies the need to either bring litigation or be subjected to litigation. So it's something we handle on a regular basis.
Okay, thank you. So I'll start from Lisa. When does a U.S. court have jurisdiction over a foreign party? I think that would be a good place where to start from.
Thank you, Roberto. It's a great question. And this answer, I think, applies generally to all courts in the US, so not just California. But it's unfortunately a question that will arise at least once for most foreign companies who do business in the United States. Generally, jurisdiction is the official party, the official power of a US court to make legal and enforceable decisions over a case. So the US does not automatically have jurisdiction over a foreign party. But in general, if you are doing business in the United States, it is likely that you will be subject to jurisdiction in one or more US courts. The circumstances in which a foreign company is subject to US jurisdiction, it really depends on the particular facts and circumstances of either the litigation that is filed or the way the company does business in the US. For example, if a large foreign company does continuous business in the US, let's say they advertise throughout the US or they specifically advertise in a state and in a lot of advertising, or if they're registered to do business in a specific state, that will often confer jurisdiction over that company. We see that most frequently with large foreign companies who do a large amount of business in the United States. The other way in which a US court can get jurisdiction over a foreign company relates to the specific lawsuit at question. So, if there are enough contacts related to that lawsuit, in other words, if a company let's say that there is a lawsuit regarding a manufacturing defect of a product that a foreign company has manufactured. Somebody was injured by that product. The question then becomes, did that company advertise for that product in that state? Did that company have a service agreement in which they perform services on that product in that particular state? Did they have contracts with a distributor in that state? Those are the type of questions we'd ask to determine whether or not a court would have jurisdiction over a foreign company.
Okay, thank you. Antonio, over to you. And what is the main, or what the difference between the state and the U.S. Federal court? When do we, go to either place?
So one of the peculiar elements of U.S. jurisprudence is that the United States is a federal republic. As such, it has essentially two court systems, two parallel court systems, federal courts and state courts. In the case of state courts, each state has its own court system. So you're looking at 50 court systems plus the District of Columbia plus the territories. And state courts are courts of general jurisdiction. In other words, if you are subject to jurisdiction in that state, the state court can decide any type of case or controversy that's presented to it. Federal courts, on the other hand, are courts of limited jurisdiction. They have jurisdiction only over two things. One is questions of federal law, exclusively or predominantly questions of federal law. So, for example, if you're involved in a trademark dispute and the trademark legislation is federal legislation, which it is, then federal courts would decide that dispute. The second manner in which you can find yourself in federal court is what we call diversity jurisdiction. In other words, the parties to the controversy are from different states or different nations. And that is very common for our clients or for foreign defendants generally. And it is very common that they may be subject to jurisdiction in federal court and have access to federal court as long as there is diversity, as I said before, and there is an amount in controversy in excess of $75,000. So if it's a lawsuit of some substance and there is diversity, you have access to federal court. Federal court is where you want to be generally. It's faster, more organized. The judges are generally more competent. And they tend to be less of a biased forum. State court is very provincial. If you find yourself in state court in one of the southern states, for example, that's not a great place to be because you will be seen as the outsider, literally the foreigner. And I think you're going to have some disadvantages. Now, it's not supposed to work that way, but the reality is that it does work that way. Federal court, on the other hand, presents a more level playing field and a better opportunity generally to defend yourself. So one of the first questions Lisa and I always look at when a case presents itself is, even if the case is filed in state court, can we remove it to federal court? Do we have the basis for removal? And we look at that very, very carefully because deciding whether you play in one field or another field makes a very big difference.
Okay, thank you, Antonio. Now, a question for both. How does a contract impact jurisdiction? Maybe you can start here, Lisa.
Yeah, a contract impacts jurisdiction because if a contract that's entered into the U.S. has a clause that specifies jurisdiction, in other words, US contracts often have a choice of law or choice of venue clause. That's something that you may see with your contracts with companies in the US. Those are clauses that identify what courts would a dispute be heard in and what type of law would be applied. For example, if you have a contract with a distributor in New York or somewhere, and that clause says New York law will govern and the disputes will be heard in New York courts, then that company sues you in California. California would not obviously have jurisdiction over that disagreement as long as it related to the contract. Only New York courts would. So that company would then have to sue in New York courts. So the contract is important. Those clauses are important because it allows you to choose those venues, those courts, as Antonio just mentioned, that you're most comfortable in or that you feel would be most favorable over your dispute.
Okay, Antonio?
Well, then you have the opposite set of circumstances, right? The contract does not specify a choice of law or choice of venue. And in that case, you fall back to fundamental principles of choice of law. And those legal principles are, complex and often confusing. But they typically will say something like, if there is a contract and there is a dispute involving the contract, then jurisdiction lies in the state where the contract was to be performed. And that sounds very good, doesn't it? However, that really doesn't answer the question most of the time, because performance of a contract, particularly a complex contract, typically takes place in a number of locations. There's performance, for example, a supply contract for machinery. The buyer of the machinery is performing by making payment from a US bank to, say, a European company that manufactures the machinery. The European company, on the other hand, is performing by building the machinery, testing it, designing the machinery, building it, testing it, and ultimately shipping it to the United States and typically installing it and putting it in use. So you can see that the seller's performance in those circumstances actually partially takes place in a foreign country, the design, the manufacture, the testing, and the shipping, and partially, but very importantly, also takes place in the United States when you look at installation and put in service. Therefore, the issue of the controlling law, the venue, the jurisdiction will heavily depend on what the parties actually do. And what's most interesting about it is that in the world of email and electronic communication, you can have a contract that is silent about jurisdiction and venue, but then you can have an email exchange that modifies it, because the general rule is that a written contract can be modified by a writing. And the general rule is that an exchange of email constitutes a writing. So you may have an email between the parties that says, look, if we ever disagree about anything, we're going to work this out in New York. It doesn't even have to say New York courts. It could say in New York, simply. So now you have the semblance of a modification to the agreement that actually moves the dispute from, say, Europe to the United States. So you need to be very, very mindful of those clauses. And my best advice, frankly, is to have the contract written very carefully, reviewed very carefully with an eye to the potential disagreement. It's easy. You enter into a contract. It's like a honeymoon. Everybody loves each other, right? But at some point, you may stop loving each other. And if you do, who's going to decide how you split up the household goods? And that's really something that the clients can run in front of and prevent and plan and implement in a way that is both effective and dynamic. And that's what we recommend.
Yeah, totally agree with that. How about we wrap up this first chat with a takeaway? Maybe Lisa?
Yeah, thank you. The key takeaway, I think, from this presentation on jurisdiction would be that don't always accept that jurisdictional requirements are met if you're brought into a U.S. lawsuit. Immediately, you should hire U.S. counsel to help you determine if jurisdiction's met. And often, our firm has been able to get foreign companies out of major litigation by filing a motion to dismiss for lack of jurisdiction because that court did not have jurisdiction over that foreign company. So make sure to not accept it if you're properly served. Do not accept that jurisdiction is met. Talk to a lawyer. See if that is something that would be plausible to get out of a case based on lack of jurisdiction.
Okay, thank you. Antonio?
Obviously, I certainly agree with Lisa. I'm only going to add something. Try and play the ball early in sports terms, right? If you're doing business in the United States, certainly always include jurisdictional or venue clauses in your contracts so that you have a voice, a choice in deciding where you're going to debate right and wrong. But I'll go beyond that and really give you some final advice. Get out of court if you can. In other words, make sure your contracts actually have a binding arbitration clause. The best venue to litigate in the United States for a foreign company is private arbitration. It is fast, it is private, confidential, so there's no reputational risk for the company. You avoid the jury system, which we have in the United States in civil cases, which can be incredibly unpredictable. And you're going to resolve the matter without the possibility of appeal. And that means that typically within 8 to 12 months, you have a resolution. Now, you may win or you may lose. That is entirely to be determined by the arbitrator. But at least you're going to have a resolution. And while arbitration can be expensive, it is still a lot cheaper than U.S. litigation.
Thank you. Point taken. And I think this is a good place where we can wrap up and maybe start from here. So from arbitration and how to do that, what chamber, etc., we can consider next time. So thanks a lot, Lisa and Antonio, and talk soon.
Thank you.
Thank you, Roberto. Thank you very much.